A very good evening and welcome to this legal side of life. This is Legally Speaking. I am Nancy Lima, and tonight we talk matters law. We are talking about the life and death sentences. Now, a landmark ruling in 2017 by the Supreme Court declaring the mandatory death penalty as unconstitutional sparked a whole debate on whether its effectiveness should continue, should it be out of the Constitution or not. And as well as on July 11th this year, 2023, an appellate court in Malindi declared mandatory life sentences as unconstitutional. Tonight we want to unpack what exactly does a life sentence entail. What are the kind of charges that warrant a life sentence? What are the kind of charges that warrant a death penalty? We're breaking it all down right here with my very able panelists here in studio. Right next to me is Kipchumba Nyorsok, advocate of the High Court. Karibu.
Asante sana Nilima.
And on the far end is Elijah RUTO, a human rights activist.
Thank you very much
Karibu.
for having me. Asante.
Welcome, gentlemen. And you see, when we talk about death and life sentence, these are things that people don't like to talk about much.
Sure.
But we have to talk about them. But even before we begin, I want us to just get an understanding from our viewers what they understand by death and life sentences and what warrants that. So, Director, if we can have the word on the street on the same before we begin.
Kama upeani maisha ufai kuwa. Mwenyezi Mungu ndo tuko na ruhusa ya kuchukua mtu. Mtu huvunja sheria, kuna mtu hawezi vunja sheria. Lakini sikukuwa na kifungu kidogo mtu anaweza jirekebisha. Alafu arudi huko nje mambo ikuwe poa. Hakuna hata unavyopewa life sentence, kunafaa kuwekwa miaka kadhaa, unafungwa miaka kadhaa unaachiliwa. Ufai kufungiwa maisha.
According to me, life sentence hata death sentence naweza suggest ikuwe according to ile ngori umefanya. Hakuna vyovyote vile unaweza uwa mwenzako you expect ufanyiwe fair judgment. Hakuna vyovyote vile utadefile mtoto mdogo you expect upatiwe fair judgment.
Maoni yangu kuhusu hiyo sentence, life sentence na death sentence, naona afadhali yekwe kwa sababu Kenya kumekuwa na mambo ya corruption na vitu zina go for free, watu wanawekwa ndani. After some time unasikia tu kitu imeisha. Kuna cases pia za mambo kama rape, mambo ya kuua watu, murder. So hizo vitu zinafaa kwa life sentence ama death sentence.
Mtu yani kama amekosa kufungwa, mimi kwa maoni yangu naona sio vizuri mtu aende anyongwe. Hata afadhali aachiwe uhai na apewe punishment huko, akae huko mpaka kifo yake, lakini sio kumaliza mtu.
Kenya unataka life sentence ikuwe kwa watu kama wale wanafanya corruption, unaona? Because corruption and drawback and everything. So watu ukisema kuna life sentence kwa mtu anapatikana corruption, itaisha. Unaona? Ndio sema kuna kesi ya corruption na anaachiliwa na peana cash bill and whatever anaachiliwa. Hiyo nafaa tuwapatie life sentence those people.
Si vizuri mtu afungwe maisha, na pia si vizuri awekwe kwa kinyongo. So kitu yenye mtu anaweza fanyiwa kama in case amekosa ni pengine apewe punishment, yes, lakini si ile ya maisha.
Hapa Kenya death sentence haifai kuapply. Sasa yenyewe sio kila mtu anataka kukufa. Hata huyo mwenye amekosea hawezi taka kukufa. Lakini sasa anafaa afungwe akae jela miaka yake yote mpaka akufie huko.
Right, and those are opinions of Kenyans on the street. They seem to have a great understanding of what life and death sentence actually entail. So let's start with you, Kipchumba. So given that those are the varied views, some people think there are some cases where a death sentence should be applicable or life sentence should be applicable. So let's just start from which charges warrant a life sentence.
Well, thank you so much, Nelima. Thank you for having us once again. And very interesting conversation from Kenyans there.
Right.
They're giving their views. Very interesting. So number one, Let me begin somewhere first. Article 26 of the Constitution guarantees the right to life. Under the same Constitution that under Article 26, the right to life is actually qualified, that everybody has a right to life, and that right can only be deprived unless another law or the Constitution allows. If you proceed to Article 24 of the Constitution, it provides for limitations of rights, that the rights as enshrined in the Bill of Rights can be enjoined to a certain extent, and they can be limited.
Right.
And then Article 24 gives a prescription on how the requirements for a law to be limited. So you find that other than the Constitution, we have other enabling legislations. One of them is the Penal Code that prescribed for punishment for all offenses that can be committed within the Republic of Kenya. So you ask what kind of crimes will warrant a person to be meted with the punishment of death penalty.
Right.
So you find that there are 4 categories of those offenses. They're actually capital offenses. The first one is treason, and the second one is murder. The third one is robbery with violence, and the fourth one is administering an oath to commit an offense. So those are the 4 broad categories of offenses as enshrined in the Penal Code that will attract the penalty of death penalty. Yes.
Right. And let me bring you in, Elijah. As a human rights activist, there is a death sentence provision in our Constitution, according to its Article, is it 26? Yes. And the third bit of it says a person shall not be deprived of life intentionally, except to the extent authorized by the Constitution or other written law.
Yes, I want us to also contextualize the wishes
Right.
and aspirations of the Kenyan people.
Okay.
That say that is the only limitation to the right to life. We understand it starts at conception. From a human rights perspective, also Article 25 tells us that international laws are part of Kenyan law.
Right.
And Kenya has ratified several international instruments. For example, the International Convention on Civil and Political Rights. This convention commends the states to abolish the death penalty. So then we need to reflect as Kenyans and say, yes, our aspirations are saying we are giving everyone the right to life, but as to what extent? Look at how we are practicing the death penalty. Since 1987, no one has been hanged or that provision has been exercised.
Right.
So we have taken the de facto of putting a moratorium on the death penalty. So in terms of the aspirations of the Kenyan people and effecting, giving life to the spirit of the Constitution,
Right.
then I would say without fear of that it is the aspirations of Kenyans also that we give effect in the sense that we move towards doing away with the death penalty. There are varied reasons and there are various proponents either for retaining and those who wish to abolish,
Right.
as just has been demonstrated by the views of the Kenyan people that have just been shared before now. And I just want to point out that we did carry out a study recently, and we also launched, and we gathered opinions from Kenyans. We first from opinion shapers that include lawyers, civil society representatives,
Right.
and other public entities, as those people who shape opinions, and then just the ordinary mwananchi. And for them, for the opinion shapers, 90% were calling for the abolition. Then for the ordinary Kenyan mwananchi, 51% were calling for the retention. But once further questions were asked to them as to the fact that at times an individual may be wrongfully charged and therefore might face the death penalty based on wrongful charges, then automatically that number reduces to 28% for those who are calling for the retention. So you can see that we are gradually moving away from the idea of using death as a form of punishment, right, or causing deterrence as a nation. And so to us, from the human rights perspective, it has always been our position that there is no excuse for using death or killing. No government, no individual should be given that power to decide that you die or the other person lives.
Should play God.
Yes.
But then what is really the purpose of a sentence?
Yes, and that's a very interesting question.
Right.
And even as we grapple with this, it's a global issue actually, on the issue of death penalty. Remember, a lot of countries in the world still apply or still enforce death penalty. Then he has brought up the question very well, that what purpose then does criminal law seek to achieve? It depends on different school of thought. There are those people who believe that the purpose of criminal law is to deter the public so that they refrain from committing those crimes. But the question is, Nelima, you find that people commit murder every day. People know that if I commit murder, I'm going to be penalized to death. So you come and conclude that the element of deterrence per se in meeting this offense is not really applicable, because people have been killing each other for quite some time. Number two, they say that is to reform the offender. That's one of the reasons that we have criminal law in force. Then if that is the goal, if you want to reform an individual, condemning that individual to death penalty, then that does not achieve the purpose of criminal law. So the essence of criminal law, from the human rights perspective and from his human rights background, is that criminal law is supposed to, of course, reform the offender in the society, so that that person, once he's returned back to the society, that person ought to have really transformed and
so can be well integrated back to the society.
So if you met this offense, and when you come to our constitution, the death penalty, as it has been enshrined in the penal code itself, is very brutal. You say that a person who is found guilty of those offenses that I've listed shall be punished by death and by hanging. You see the cruel nature that the penal code has integrated in terms of the terminology. And that is where now our judges come in when interpreting that provision. And according to them, they are saying that the use of the term shall, that mandatory term, it in itself is unconstitutional. Because when you are passing a sentence against an individual who has committed those offenses, that person is normally accorded what is called mitigation. That that person is supposed to mitigate before the court, and the court is mandated to take into consideration the mitigation of that individual.
So the mitigations are the appeals that they can make?
No, not appeals. When before sentencing, the court will ask a person, una nini ya kueleza hii mahakama ili iweze kukusikiza, and then say a person say I'm a single parent, I raise the family, I'm the breadwinner. So the court, when meting out a sentence, is supposed to take into those considerations. But the penal code does not give the discretion to the court so that the court can incorporate those mitigation that the accused person will give in court. So by that virtue, then the court in the Supreme Court stated that as far as the death penalty is mandatory, then to that extent it is unconstitutional. A judge.
Okay, so then it means that the life sentence in itself is not a problem, but the mandatory nature.
Exactly, that's
so
the point.
It means that judges can have discretion depending on a particular case.
Exactly, because cases are different. People commit these offenses in a different setting. So what the court is saying that death penalty as it is constitutional, because the constitution allows for the limitation to the right of life. But insofar as it is mandatory, that the court, once you are found guilty of robbery with violence or murder, the court does not have any discretion other than to convict you to
Right.
death or life imprisonment. So to that extent, the court says no. A person can commit murder, but it's not murder. It's, there are circumstances under which that person, there are prevailing circumstances that led that person to commit murder, and to that extent, the court perhaps should have a discretion
Right.
in seeing how to sentence this person. So to that extent is what the court is now saying. To that extent, we say the court must have a leeway in trying to sentence or to meet. But now then, there's a very, very important question that comes out from that kind of scenario. And in fact, this was one of the questions that was raised by Justice Warsame. I was seeing during the vetting of judges and magistrates.
Right.
And he asked to Justice Joel Ngugi that is sentencing a judicial role or is it a parliamentary role? Because it is parliament that passes the legislation, it is parliament that has enacted the penal code.
Right.
And it is parliament that has put those clauses, those wordings. But now you find a judge coming and say, for me, the words used in the penal code is not really good. I need to reduce. Then the judges are like, as a judge, am I supposed to interpret the law as it is, or am I supposed to give just suggestion? That's where now
Right.
scholars in the field of death penalty and the wordings of legislation are torn in between. That is sentencing a judicial role, or is it a legislative role?
Right.
Yes.
And Rotok, let me bring you in. There are some states, there is different states in America that execute people by different ways. Now the death sentencing. And the argument is that family and friends then get closure. What do you make of it?
Well, many studies also equally, I would wish to state that have looked into the issue about death penalty and has been conflicted and caused confusion within different states in the United States, because most of the arguments have not been based on empirical studies that pinpoint the actual views from both the victims and also the offenders. And so from the Kenyan context, it is important that the idea about death penalty being deterrence or providing closure does not hold water in this sense.
Right.
Many victims or families of victims of persons either through who their members have died or who are robbed violently,
Right.
have expressed later on that indeed death, killing another person hasn't provided them with any form of healing, because it only perpetuates the cycle of violence where you kill, then you are also killed. So that in itself, it is backward, and it defeats the purposes of having corrective approaches apart from retribution on behalf of the families.
Right.
Then the rehabilitative aspect misses. We've had experiences as a commission to go to prisons and have conversations with persons who've been committed to the death penalty, and the harrowing experiences of being in a limbo into their psyche has adversely affected them, in the sense that they do not know whether one day a president or one day the attorney general will effect that law, and an individual may be appointed to come and effect the death penalty.
Right.
So with that, the indeterminate nature where you're put in prison, you are not allowed to participate in any recreational activity, you're not allowed to participate in the education and any other things that would aid your development within the confines of prison. And so you're just there sitting and waiting. And I think no one wants to wait for years and years just for something to take action. And so with that, it amounts to torture, cruel and degrading treatment as a form of punishment. Additionally, it affects the human dignity
Right.
adversely, in the sense that when you look at also the experience, and we further interrogated some of the reasons as to why they committed such offenses, specifically the robbery with violence and murder cases. And when you interact with the prisoners, they would tell you that the leading cause was they were looking for something of financial gain. And when you look back into the background, you'd find that a majority were low-income earners. Majority of them did not have a proper education,
right,
and so they did not have the wherewithal or the opportunities to better themselves within society. So the commission of that crime was driven by other social factors, such as the need for fending for themselves, and other issues such as peer pressure, and then also elements of self-defense in some instances.
Some cases of
yes, and also provocation out of the altercations that they would have. And so generally you would find that these provisions are actually targeting poor members of our society.
Okay, but don't you think then, if we say mandatory life sentences are unconstitutional, then it gives a leeway for people to commit crime, knowing that then I will not do life, perhaps it will be 30 years. Don't you think it gives a leeway for crime to be prevalent?
I would hold a contrary opinion. It does not, because it is a fact that crime continues to be committed on a day-to-day basis within our society, and there are various ways in which such crimes can be addressed. Now, to the issue specifically to mandatory sentences, as Kipchumba had rightly put, you cannot tie the hands of a judge from exercise, or a magistrate from exercising their discretion to look into the evidence that has been presented before him or her, the facts, the law, and also those now mitigating factors that the person, the accused person, is facing. And so with that, when you automatically just say, if you did this, automatically you are sentenced to death or you're sentenced to life imprisonment, then you're limiting again, you're interfering with the discretion of the judge, which again interferes overall with the independence of the judiciary. So in such cases, then it is important that such preserves are upheld at all times. Additionally, in relation to some of the sentences that have bedeviled, you need to look into also some of the demographics within our prisons, and you will realize that there's a huge category of young people who because of the nature of the offense that they committed, especially sexual offenses, are facing life sentences. And because of the fact that we all are growing, and over time you get an opportunity to reflect back about the crime that you did, and through the process of rehabilitation that occurs in prison, a person can be able to reform. And when that person reforms, they should be entitled to remission. Remission means that once you have served at least 2/3 of your sentence, then if you're on good behavior, if the prison officers assess you and then they submit a report to the Power of Mercy Advisory Committee, then with good behavior you can come out after having served 2/3 of your sentence. But when you say now life, or when you say death, it defeats the purpose of that reforming. So it needs us to rethink and reflect. And I'm happy because currently there is a push from the National Assembly through the leader of minority, Opiah Wandayi, who has brought out a bill that is calling for the abolition of death penalty and for the commutal of death penalty to life sentences. The same, we recently, the president commuted inmates who are serving death row to life sentences. There's also another committee within the judiciary that has been appointed by the Chief Justice to look at now the penal laws, and part of the issues that they would be looking at is how to effect the meaning of what is life, what is the sentence, what is the minimum sentence that a person should serve when you say you are serving a life sentence, because it doesn't necessarily mean that when you say life sentence, it automatically refers that you will serve until the natural death of the accused person.
Right, and you brought in something very interesting, that someone could reform later on in case they're charged of and found guilty of, say, defilement. And there was a very interesting case in Malindi, one that I just mentioned, where the appeal court, it termed the mandatory life sentences as unconstitutional, a Malindi court. And this was in a case of a man who had been accused of defiling a 4-year-old. And he had his sentence reduced from life to around 40 years. And of course, sparking just a lot of reaction, because many people were questioning, this is a 4-year-old, very young girl. And so to reduce the sentence from life to just 40 years, they said, then is it
where's
really
the balance?
exactly?
Yes. So because now there's a test that you have to apply when you are sitting in the bench as a judge, and that test is called the proportionality test.
Right.
What is the proportionality of the sentence you are meeting against an accused person vis-a-vis, it's called the scale of justice. So the court in its wisdom, finding that that sentence was unconstitutional, for me, it's well founded in law. Because number one, it is the court that is well seized with the facts of the case as at that point. There are other factors that may lead a person to commit a crime. Maybe when the person is intoxicated, so many things, maybe he's going through trauma, so many things come into play. So to that extent, when the court is seized of the facts of the matter, and the court is the custodian,
Right.
we normally say that an accused person has nowhere else to go other than the court to safeguard his rights or to protect him. In fact, there's a term that Justice Odunga used, that an accused person is always the darling of the court, because this person has been vilified by the society. The society has already thrown mud at him or her.
Interesting, a darling.
Yes, so
of
it
the
is
court.
now it is now upon the court, seized with the facts of the case, to determine and to allow it to have a discretion to apply a certain sentence. So to that end, the court, having read and having perused through the file and having made its own determination, having also the role to safeguard the interest of the public and of course the interest of the accused person, has actually made a very progressive decision holding that.
Right.
My colleague is an advocate, has actually put it very well, that when you look at this mandatory nature of these acts, they are very, very, very derogatory. They are inhumane because of the element of you are putting somebody you're imprisoning somebody to life imprisonment. So what is life? Is life the life expectancy of a person? Number two, you are saying you are being condemned to death. And the nature of the wordings of the death is by hanging. Other nations have moved ahead. They can sedate you until you die. They can execute you. But in the Kenyan setting, it is very cruel. So he also mentioned international instruments,
Right.
which are by virtue of Article 2 and sub-Article 5 of the Constitution, gives the laws which have been ratified by Kenya form part of this country, and give an example of the International Convention of Civil and Political Rights, whereby there's a protocol that recommends to states that they should move towards abolishing death penalty. Kenya is not a party or is not privy to that protocol, but we are, as a country, we are headed in the right direction, because we can see actually that we're having this conversation.
Right.
But be that as it may,
Okay.
in as much as there are some exceptions to where a person cannot, in as much as he has been found guilty of those capital offenses, there are certain categories of people who cannot be subjected to death penalty. And the penal code has provided for 4 categories of people. Number 1 is a pregnant woman.
Right.
A pregnant woman cannot be subjected to death penalty. A person who is under the age of 18 years old cannot also be subjected to death penalty. We have got people who are insane, so people who commit crimes, they commit murder when maybe they are mentally ill.
Yeah.
Those people cannot actually also be subjected to death penalty. So the constitution, the penal code has gone also to an extra mile to try and also to balance on who can be meted with death penalty or who cannot be.
And briefly, let's talk about the embattled evangelist Paul Mackenzie. He's been given additional 47 days. And yesterday he was complaining before the court that while in custody he's gone for 2 days without food and he's not been able to take a shower. So Rotok, let me bring you in and just the matter is still in court. He is still innocent until proven guilty. So how the accused persons are treated while in custody?
Thank you very much. This is a perennial problem that has affected our criminal justice system over the years. And it is important that the rights of an accused person are maintained, are upheld, because you cannot suspend human rights despite the fact that on the basis that you're deprived of your liberty.
Right.
And to that extent, I would state categorically that no person should be treated in an inhumane manner, or should be punished, or should be denied essential services such as the right to food while in custody. And such issues should be raised within the court, and also if the court, of course, will examine them and then give the proper directions. And further, the accused person will still have that right to even petition further to another court when these violations occur.
Right.
And at no point should anyone be tortured, be beaten up, or for the purposes of either extracting information, confession, or even punishing them. And so there is the Prevention of Torture Act, which spells out various forms in which an individual can be tortured. And so it's important that the police who are caring for him within custody adhere to the provisions of the Prevention of Torture Act to ensure that despite the charges that they are faced, despite the public outcry, and even statements that have been issued by some leaders that he should never be left, he should never see the light outside prisons or outside jail, then we would say that at no point does he lose out his rights.
Right. And of course, still on Paul Mackenzie's case, the critics have argued then arresting someone without substantial evidence, then keeping them in custody as investigations are ongoing, unlike some other countries where until they have very substantial evidence, will they arrest a suspect. So do we go about it in the not so correct way?
Yeah, I think in the Mackenzie case, I think we are now losing it, because the prosecution comes up with excuses every now and then for trying to charge him, but they do not come with substantial charges, and the man is actually being held in custody, violating his individual rights. As I told you earlier on, that the accused person is a darling of the court. So the court in this scenario ought to strike a balance, but because sometimes, a person who has been denied by the society sometimes can be, for his own safety and for his own sake, he can still be put under custody, so that also to protect him as an individual. So in this essence, they ought to be a balance. The way my colleague has put it, that he is an accused person, he is innocent until proven otherwise, and the Constitution provides for that. We have a very progressive constitution in the world that has and Article 49 that we discussed last time when we were here for the very first time in this show, legally speaking, on the right of the accused person under Article 49, that the person has to be accorded the right to bail as soon as it is practicable. So in this instance, the way that the prosecution is handling the case and the pronouncements from cabinet secretaries, I had the cabinet secretary for Interior actually saying the exact words that he'll ensure that such people like Mackenzie cannot see the light of day.
Right.
It seems that,
and it's a matter that is still in court.
It's exactly. Right. And these are professors of law. You know, then it raises a lot of question as to the kind of leaders that we have. Those pronouncements, let the court make such pronouncement, but other people of the public are supposed to restrain and to treat this gentleman, Mr. Mackenzie, humanly.
Right, and as we close, maybe just final remarks, but I'll pose this to you, RUTO. Then we trust the justice system and our courts, and they convict suspects beyond reasonable doubt. And so when there's beyond reasonable doubt, then life sentence or death sentence then would be in order if the case has been proven beyond reasonable doubt. What are your thoughts?
Okay, yes, thank you. As a closing, I would say that at the moment, life sentences has not been, declared unconstitutional, but just the mandatory nature.
The mandatory, yes.
And so, for us, we would say that there is progress, both from the judiciary, from the legislature, and even from the executive. There is a move towards treating accused persons or persons who've been now sentenced in a more humane manner in accordance to the various treaties that we have assigned to and that we have ratified. And so towards that, I would say that it is for the courts to decide the level in which, based on the circumstances on the case that they handle, it is for them to decide the length of service that this individual should serve when they have been found guilty and convicted and also sentenced. Right. But that cannot be restricted to say that for this offense, it must be either death or life. Let that be left to the judges. But more importantly is that we need to reflect upon our laws, and more so to the public, we need to reflect about what are our values, what are our principles.
Right.
Are we going to say that for some crimes we want, in punishing people, we want to use death, or we want to use means in which that it will defeat the essence of either reforming an individual or making the society better? So that goes to the public. And then to the justice actors, then I would say that it's important that we adhere to human rights principles, and this calls for review of all our laws, including the provisions of the law that gives effect to now the operationalizing of the death penalty. We are calling for the abolition, for the repealing of the death penalty,
right,
so that we treat persons in a more humane manner. We allow judges to sentence persons within the meaning of life, which will be determined by very soon through a task force that has been set out to now look at the meaning of life.
Right.
So that, and through that, we will be able to ensure that the judiciary works for the people, and also the people will see justice done in a manner that is also humane, and they will see that both the rights of the victims and also any accused person and also persons who are prisoners are upheld at all times. Thank you.
Right. And your sentiments, Kipchumba, as we close?
Yes, for me, the rule of law should be the governing principle insofar as for any prosperous society, and that each party in the justice sector should always be guarded by the principles of human rights and the rule of law, and that we all belong to the same society, and mistakes, once a person has done a mistake, they can be subject to be remorseful, or they can reform.
Right.
So these are people belonging to us as a community, and we should never condemn them for what the mistakes that they do.
Okay. Thank you so much. I know it's a broad conversation.
It is.
Perhaps we can have a part 2
Yes.
of the same,
Yes.
just to break down so that our viewers can understand. Sometimes
Exactly.
the constitution, the law has jargons.
I know.
But now this is the purpose of this show.
Exactly.
To help just people understand,
Yes.
break down all these things. And thank you so much for watching. We're having this conversation tonight on Legally Speaking about the puzzle that is there between the life and the death sentences in the country. I have been speaking to Kipchumba Nyarsoko, who is an advocate of the High Court, and Elijah Rutoko, who is a human rights activist. Thank you so much for watching. I am Nancy Nelima. Our sign language interpreter has been Felista Adundo. Until next time, let's keep safe and, of course, by the law. Good night.